Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 361 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things compliance related. Today I have with me Don Fischer. Don is an export control lawyer practicing in San Francisco and Washington. He is an expert in U.S. export control, together with FCPA regulations. He's done extensive strategic and practical work in helping companies implement cost-effective, risk-appropriate compliance programs in the export control area. He has dealt proactively with systems to comply with Chinese export and import laws, and he's done specific export control services relating to risk assessments, export process development, export licenses under EAR, ITAR, and OFAC, technology control plans, and requests for advisory opinions. In this episode, we take a look at what are the basics of export controls, which government agencies regulate exports. Take a look at the always tricky question of what is a deemed export. We consider whether or not export control should be evaluated by defense contractors only or other commercial operations. How do these requirements impact your company? We touch upon some of the consequences for getting it wrong, and what are some of the challenges that Don has seen companies face in becoming compliant with export control laws. It's a fascinating exploration of a subject that touches the anti-corruption compliance practitioner actually more than you might think. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode of the FCPA Compliance Report. Today, we're going to take things in a little bit different direction as I have Don Fischer with me of Don Fischer and Associates, and we're going to talk about export controls. Most people know that I have advocated the concept of compliance convergence, which is different types of compliance, anti-corruption compliance, anti-money laundering compliance, and certainly export control compliance. And that each of the compliance practitioners in those specialities need to have a familiarity with the others because they interact and intersect so much. Once upon a time, for my sins, I was appointed an export control director of a oilfield service company, so I have some familiarity with this topic and understand a little bit of how they all relate. But I asked Don if he could take some time to visit with us and really give us a good grounding and introduction into export control. So Don, with that somewhat long-winded introduction, thanks for taking the time to visit with me today, and welcome.
Thank you, Tom. My pleasure.
So why don't we just kind of start with the basics, Don, and what are export controls?
So, Tom, these are the federal regulations that come from various government agencies, primarily the Departments of Commerce, Defense, State, and Treasury. But there are also other agencies that get involved. For example, the Department of Energy, the Nuclear Regulatory Commission, the Department of Agriculture, Homeland Security, Immigration, NSA. And essentially, they regulate two things. First of all, what items, such as instruments, software, materials, and technology, that may have some national security sensitivity or other kinds of sensitivity. They regulate what we can transfer or send out of the country internationally by any means. And if we are going to export something that meets a level of sensitivity by one of these agencies' definitions, then it may require an export license or prior authorization. They also regulate, to some degree, the extent to which we share export control technology with foreign nationals who are present in our community under various visa programs. And that's true whether these individuals are in our corporate community or in our university research community, et cetera. And the idea is that when we share export control technology with an individual who is visaed to be here for a certain period of time that is finite, presumptively at the end of that period, that individual would either return home to their country of citizenship or to a third country, but that technology would exit with them. The export, however, occurs at the point of access or use of the information, potentially long before that person gets on a plane to leave. So those are the two primary areas that the regulations address. And then there are some other requirements we can talk about also.
Don, you said a lot in there. Let me unpack a couple of things. The first one was you talked about technology. And one of the things that many people who sit in the general counsel's office, anti-corruption compliance practitioners really don't understand is that there is a level of license requirement for various types of technology, and the things that perhaps an anti-corruption compliance specialist does not understand is covered by a license. Could be an encryption level in routine software, or something I don't want to say as bland as that, but that the level of technology can vary widely, and it does not have to be simply have a military application. It can have a business application. It can have a university application. You have many different types of applications. So that's one of the reasons that when I get a case that has any export control implications, I always run to someone like you who would know yes or no, this is EAR 99 or this requires a license. And if it does require a license, how far that license or how robust that license processing may be. The second thing you said, though, was a concept that really still confuses a lot of people, and I would call it a deemed export, but you give a much more detailed explanation of it, which is when you deliver the information to a foreign national, it's not where that occurs, it's when it occurs, and if it occurs in the United States, that's what I've always understood to be a deemed export. So I was wondering if you might expound a little bit more on both of those points.
Yes. So with respect to things that are export controlled, you're quite right that from the government's perspective, they could be items, instruments, software, materials, or proprietary technology, that is to say, technology which is not already in the public domain, that is either dual use, that is to say, civilian, by design and application, and we may use it in industry and we may use it in research, but is sophisticated enough to inherently have a defense capability. So based on the Commerce Department's control list, they require prior authorization, or they regulate items that they consider of dual use concern. The State Department, on the other hand, regulates or has jurisdiction over items that are specially designed or modified for defense purposes. And the definition of defense under the ITAR can actually have many broad applications. We can purchase best-in-class research instruments that were designed for defense purposes. They're commercially available, but it's up to us to manage either their international transfer or the sharing of those items with foreign nationals. So there's the dual use side, and then there is the defense side. And you raise a good point that with respect to foreign nationals and this concept of deemed export, it's nuanced insofar as we might have certain kinds of instruments, defense instruments, or we may have certain kinds of technology. And when we provide that to a foreign national for purposes of their particular position in research or in industry, then that is considered an export because, as I said earlier, that individual is presumed to be in the United States only for a finite period of time. And it's at the point of sharing that technology, either by access to it or use of it, depending on the type of technology and whether the State Department or Commerce is governing it. When that technology is accessed or used, that's effectively when the export occurs. So these days, many corporations who are manufacturers and distributors, who are R&D engineering, design houses across any number of different industries, when they have foreign national employees or guests, could be visitors or research fellows or scholars visiting from other countries. That's certainly common in universities. This is an area that they pay attention to. And when it comes to getting export licenses, it's typically on from the dual use perspective, it's on a country by country, item by item basis. So I might need to get a license for an item that I would send to, for example, to Singapore, but might not need a license for that same item to send to France. And likewise, to share it with a Singaporean foreign national might require an export license, but not necessarily with a French foreign national.
Don, if I'm I'm in Houston, and a large part of my legal practice has been in the energy space. How do export control requirements affect sort of non-military, kind of what I would call just a regular commercial operation? You've seemed to have detailed a wide variety of areas. Does a company that really does business internationally need to be concerned with this, or is it something else?
Well, I think that to the extent that certainly any company that is exporting anything internationally, it would be of concern. And I should add that because of the national security implications, the enforcement penalties are severe. They can take the form of civil, administrative, financial penalties, which can be significant. There can be revocation of export privileges. There can be federal debarment from federal contracts. And certainly if there were intentional wrongdoing found, the matter could be referred to the Department of Justice. But to your point, Tom, I think it really affects anyone who is engaged in technology that may meet these definitions of sensitivity right here in the United States, again, to the extent that they might validly employ foreign nationals, or, for example, if they have procurement programs where they're sourcing components internationally, and those suppliers come to the United States to understand the process that's required, or if there are international customers who come to the United States to understand, what it is that they're getting, all of those things really have an impact on a domestic corporation operating in this area.
So one of the things that was, I hate to use the word bugaboo, but it's a great word, so I'll use it. A bugaboo in the energy space was the issue of hand-carried tools. Typically, oilfield service worker, particularly one in a repair, would travel to an overseas location, would take his tools with him. And these were not simply a hammer, a ratchet, and a screwdriver. These could be up to $1 million worth of sophisticated tools to work on an oil rig, to work on any type of oil field service equipment. And there was a continuing debate on whether that needed to have an export license. And I use that example as a way to introduce how does someone like yourself communicate to a anti-corruption compliance practitioner or even a business unit employee, sort of what the requirements of an export control program are, and how do you get that information out to people in the field who might be violating the law without even recognizing it?
Certainly. Well, you raise a very good point that an export can occur by any means, first of all. So it can be, conventional cargo shipment. It can be through a FedEx or UPS courier account. And is if we are hand carrying a tool of trade, occupation abroad or research abroad. What could that item be controlled? And the answer is absolutely. Now, then it depends on the sensitivity of the item and which agency, state or commerce, is actually governing it. In the case of the Commerce Department, dual-use items that we talked about earlier, there can be a license exception which says if we are transferring an item internationally, hand-carrying it temporarily, we're going to bring it back within a year, and it can remain in our effective control while we are abroad, then it may qualify for a license exception. On the other hand, if it's a State Department item, let's say, for example, we were bringing either it could be a technical data or software that is governed by the State Department, it could be a sensor, it could be any number of different kinds of instruments, then all State Department items are presumptively require an export license, even if we're just using them temporarily abroad. So it really depends on the item and the sensitivity and which agency is governing it. And I think that this is a matter of awareness. And so for anti-corruption professionals in a corporation or for those tasked with overall compliance integrity, I think it's really important to get the word out that there are these kinds of export controls that can have an impact on how the company conducts business, and so for individuals whose responsibilities either require shipment of things or the hand carrying of items, notifying the appropriate person in the company proactively of that intention is really the best thing to do. Typically, with enough time, it is possible to get an export license unless it really is an ultra-sensitive item to one of several, absolutely prohibited countries. But with enough lead time, often it's possible to get the compliance protocol in place. So I think internal communication to the individual who is designated as the export control go-to person is really critical.
Don, you listed some of the penalties that a corporation might face for a violation of export control. But one of the things that struck me when I first came into this area was this can be actually go to jail kind of stuff. That we've had cases where individuals were criminally prosecuted for violation of export control. I was wondering if you just might detail some of the higher profile cases and what that meant to those individuals' liberty.
Sure. So let's start with what I call inadvertent or negligent errors. The regulations, both the dual use controls and the State Department defense controls, they have mechanisms to disclose or to report errors that occur, and that's not, of course, uncommon, since given the complexity of the regulations, and so and normally that results, depending on the gravity of the situation, it may just result in a warning letter based on a commitment to rectify the situation going forward. However, if there are multiple errors disclosed, or if one of the agencies themselves investigates and finds the error without disclosure, then of course it might be subject to the kinds of penalty actions that we talked about. The vast majority of export control violations are due to negligence or a lack of understanding how the regulations operate. And those where the agency perceives an egregious disregard for the regulations and or intentional wrongdoing, those are the ones that may be referred to the Department of Justice for criminal prosecution. You're quite right that there are those cases exist every year, and a number of them, I can think of several in the last 2 years that have resulted in criminal sentencing and certainly criminal penalties. And the bottom line is that any entity that suffers that really is going to have a significant problem going forward, both for purposes of maintaining their export business, but also they're going to end up on a watch list that is going to be published in the Federal Register. The information would become public if there's a criminal violation, and then it can be a prohibition to actually do business with a company that is an export control violator. So the consequences, reputationally and otherwise, are severe, and that's I think a very important reason for the corporate community and the higher education research community to pay attention to this. The other thing that I would point out is that for a company that is expanding internationally and must take into account the anti-corruption regulations, how one interacts with foreign officials, there is also a segment of that which comes up in the export control regulations as well. And that has to do with the way that we provide defense services and the way in which we might pay individuals to broker services for us. So there's actually a very direct connection between the anti-corruption regulations and the FCPA and some of the export control regulations. And I think it's important to recognize that the agencies talk to each other. It never was the case, I would say even up until 5 years ago. But now we are finding that the Treasury Department, the State Department, Commerce, and Defense, they all are now systematically in touch with each other.
And Don, I wondered if a company is moving into the international market, or they listen to this podcast and think, this is something we need to take a look at. What's the best way for a company to either start the process to implement necessary oversight for export control, or even assess their risk to move forward to manage that risk from an export control perspective, I should say?
It's a great question. And I think that an export compliance program really begins with understanding what one's risk profile is. And I say that because in order for a program to be effective, it really should be proportionate to the risks involved. It should address the risks and be flexible enough to grow with the company. But I think it's actually a mistake for companies to bite off more than what they can actually handle at any one time. So typically, it is useful to have either an internal export control assessment or have someone come in and undertake an assessment that looks at the scope of business activities from the beginning in terms of sales and market development to customer service and contracts to engineering and manufacturing, procurement, IT support, HR in the case of bringing on foreign nationals, aftermarket service support, shipping and receiving, R&D. All of those functions touch export control, and I think that, or have an export control implication. And I think that by starting with an assessment, one can then say, okay, here are my top 5 risks. Here are the things that I really need to address right now. There might be other things, but I can defer those pending resolution of what is more of a priority. So a risk assessment is important. And then once we know what our risks are, then incorporating into our standard work procedures very transparent, easy to follow export processes. And I mentioned all of those phases of business development, contracts, et cetera, procurement and manufacturing and engineering. There would be an export control process incorporated into each of those functions' standard operating procedures. And once that's done, the next thing is really training, making sure that that corporate personnel, or in the case of universities, academic and research personnel, are aware that these export processes exist, why they're important, and who the go-to person is in the organization to ask for help.
Well, Donna, unfortunately, we're near the end of our time, but I was wondering if anyone wanted to follow up with you directly or find out more information about you or your firm. Could they email you, or how would they find out that information?
Absolutely. So we can be reached. I can be reached at dfischer, that's dfischer, at fischer-associates.com. So dfischer at fischer-associates.com, or through my mobile number, which is 415-987-4039. We are located in San Francisco, but have offices in Washington, Shanghai, and in Dublin. And so we try to reach as many time zones as we can.
So I've been visiting with Don Fischer of Don Fischer & Associates. It's been a fascinating discussion of what are export controls, and more importantly, what you can do as a compliance practitioner to help your company comply with this area of law. And we touched upon the convergence between export control and anti-corruption compliance. I hope to explore this with you further, Don. It's a fascinating subject. There are a fair number of enforcement actions and trials that pop up in my world that have export control considerations. And perhaps I can call upon you as our export control expert going forward. So thank you.
You're very welcome. It would be my pleasure, and I'm happy to respond to any questions which our participants and audience might have. Thanks so much.
Hello, everyone. This is Tom Fox again. I'd like to thank you again for listening to this episode of the FCPA Compliance Report. If you have any questions, you can email me at tfox@tfoxlaw.com. Also, if you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would very much help in our rankings and help get the word out about the most senior podcast in the compliance space. Also, it would help expand the Compliance Podcast Network. Thank you again for joining us on this episode of the FCPA Compliance Report, and I hope you'll join us next week for another episode. The FCPA Compliance Report is a part of the Compliance Podcast Network.